Welcome to week 4. We are at the midterm point in this course. It goes so quickly, and I wanted to start out this week by reminding you all that you do have a written assignment due in week 6. And I know I've talked about how to progress through this, and at this point you should be well into the body of your paper, but I wanted to talk a little bit about the specifics of the assignment. I had an opportunity to speak face-to-face with one of you all this week about the written assignment, and I kind of wanted to explain to the entire class what we're looking for when we're talking about how do the laws conflict. What are the internal conflicts within the legal system? If you've had the other paralegal classes, and this is where you're ending your paralegal program, you'll probably remember talking a lot about Plessy v. Ferguson and leading up into Brown v. Board of Education. This is one example of how we can have statutory law and case law evolving that changes the way that we work within the legal field. And in some ways it's a reflection of society, in some ways it's leading society, and there are all these clashes and conflicts when you talk about judicial activism, judicial restraint, what the court should be doing, avoiding that judge-made law, but recognizing that the way the Constitution was written in the 1700s may not be interpreted identically in 2024. And one other example of that, when we start talking about Plessy v. Ferguson, it was a gentleman who got on a train, sat in the front of the train in a car that was for white people. And got to remember, think about this back in the 1800s. At that point, there were separate facilities based on race. He got on it in the north and he was traveling to the south. When he got to the south, they had different expectations of where he should be sitting, and he was asked to move. This went before the Supreme Court, who at that time said separate but equal facilities were allowed under the Constitution. Then this went from the 1800s up to the 1950s, and there were cases in between there. There were changes being made. Society was changing. We had gone through World War I, World War II, where in World War II, if you'll think about it, a lot of the men had left. They weren't in the U.S. working in the factories, which brought a lot of women working alongside people of different races. They were mingling for the first time. They were working side by side. They were seeing each other. They were starting to understand the similarities rather than just focusing on the differences. So our country had changed. We had evolved from where we were living, how we were working. Things were changing. We got to the point in the 1950s where the court heard the cases surrounding Brown v. Board of Education. It was not just one case. There were several cases that made up the decision to say that separate facilities were no longer appropriate. The facilities were not equal, and we had decided at this point in the 1950s, no more separate but equal. But the court did not tell people how to implement this. So we had a change in the law from separate but equal is okay to where we evolved and we said, no, we are no longer having separate but equal facilities. We're going to integrate the schools. We're going to desegregate the schools. These were terms that were starting to be used, but there was no clear-cut direction from the court telling them how. Because if you think about it, it's not the court's job to tell people how to implement the laws. They do not implement the laws, they just determine whether or not the laws that are in place are constitutional. So at that point, it became necessary for the executive branch and the legislative branch to act. The legislative branch needed to create laws that worked on desegregating, that worked on inclusion, making those changes at a local level, at a state level, where the constituents were, meeting them where they were, raising them to the level that would be constitutional. It was not going to be the same approach all across the country. Then we had the executive branches. We had the governors and the president who were to implement those laws. If it was a federal law, then it was the president implementing it nationally. If it was a state law, it was the governors making sure that it was being implemented nationally. We got to a point with Brown v. Board of Education and subsequent cases when we look at Little Rock, Arkansas. That's another case that we've covered in previous classes, to where the governor stepped in and said, I am not allowing these schools to be desegregated. I will activate the National Guard to keep students out of the school. We are not desegregating the school. At that point, it became necessary for the president, who is over the federal laws, who needs to make sure that all of the laws are being implemented constitutionally in the state, to step in. So this is showing the dual federalism, the different levels of our government, how they work together, and how sometimes they might have to clash. If a governor is saying that we will not follow the law, then it is necessary for the federal government to come in and ensure that it is being followed. So that's one example. Another example that I gave was when you're talking about reasonable search and seizure. In the 1700s, when our Constitution was drafted, that meant someone coming into your home, taking your property that way. Today, that can be digital assets. That can be your cell phone. What are your reasonable expectations against search of your phone? So that is another way to where we're evolving. The law is the same. You still have that expectation that you will not be unreasonably searched. But what does that mean today when we're talking about digital content, when you're talking about your cell phone, when you're talking about things other than property, tangible property in a home? So that's another way. And so when we talk about this, we need to talk about policy leaders and lawmakers and how they're working to defend the positions on controversial legal issues, like when they were talking about desegregating the schools, or when we're talking about unreasonable search and seizure. And even in the unreasonable search and seizure, it started out with the Constitution, and then we evolved to the point to where we had the Miranda rights, to where the people that were being representatives of the government needed to inform the citizens of what was going to happen and what could happen and what their rights were. Now we're to the point to where we're talking about digital media, digital creations, cell phones, computers, different things like that, where we have the same concepts being applied in different ways because we as a nation have evolved. Another example would be looking at reproductive rights. That's another issue where we've got policymakers, we've got political scientists and people that are politicians and lobbyists working on an issue. Then you've got legal advocates and you've got lawyers working through cases. You've got judges having to make decisions about those cases. So you've got these different individuals who are working on the same issue from different angles, and they're bringing different things to it. It is very important to remember that a politician's role and a judge's role are very different. A politician is representing constituents from their local area, and once they get to Congress, if it's at a federal level, the entire nation. So they're representing their constituents and working together collectively for the good of the nation. When you're looking at a judge, they are looking at things based on the facts before them and the law that is before them, how that is going to apply. Then you've got attorneys who are arguing different positions to different sides of an issue before the court. So there are so many different people that are in policy making decisions, legal decisions, working on these issues. And that can make clashes happen. It can have conflicts. But there are ways that we can work through this as a nation without just butting heads and fighting and getting to polar sides. There is all that middle ground where we can come together and find ways to progress. This is not for the written assignment, but you could think about last week when I had you all looking at AI and using AI in the legal world, and how in this class you can't use AI. I don't want you all to just take the prompt and put it into an AI source and then roll it in and turn it into me as your own work. There is a place for AI to help you with some things, to help you tweak some things when you're doing a general letter. If you have a question that you want answered, but you're not submitting it as your own work, that's different. There's a place for it. Our society is evolving, and it is crazy right now, the different directions that people are taking on this, and how we're trying to decide what is plagiarism, what is unique work product. What can a lawyer say, this is my work product that I'm presenting to you? What can a client bring to an attorney and say, this is my work product, versus something that they generated with AI? If you go to ChatGPT, you can tell it to draw a picture of a girl and her dog walking down the street with red houses flying the American flag, and it will do that. But is that really your work product? You didn't draw it, you didn't select the colors, you didn't say what the little girl looked like, you didn't give an age, you didn't describe the dog. There's so much of that out there that did not come from the individual inputting the data into the AI source. So that's another way that we're looking at it right now. So I'm hoping this helps you understand what we're talking about here, looking at different components of the law and the internal conflicts within the legal system. Some of it is coming from the legislative world because there are attorneys that work drafting the law. There are attorneys that work in the legislature. There are attorneys that work in administrative bodies and environmental lawyers. There are reproductive lawyers. There are different constitutional lawyers that are arguing cases before judges who are to be neutral arbiters of the law. They're supposed to take the law before them and ensure that it was properly enacted by those, typically the government. I'm trying to be careful with my words here. But normally when we're talking about these issues, it is making sure that the government did not infringe on an individual's right. So we're looking at how the different roles in a case can play out, how the different roles in legislature versus the courts are working together to create our society's administrative regulations, statutory regulations, and case law that goes back to the Constitution but is applicable today. Hope that cleared it up. I wish we could have some interaction. I wish this was not an asynchronous element of the class. Please email me your questions. If you guys email me your questions, I can help you in advance, and that's what I want to do. So this is due in week 6. It's 1,500 word paper. Do not submit anything from AI. You have to have your own independent research. You need to be citing the textbook. You need to be using scholarly sources from the UC online library. Make sure you've got a good introduction, a thesis that's your roadmap to tell me where the paper is going to go, and that you use your body to do the analysis. You submit a conclusion that ties back to the thesis and wraps it all up so that it's a really good roadmap from the thesis all the way down to the conclusion, and we know what to expect. Okay, that's a lot on week 6. This week, on week 4, we're going to be looking at reading a case, how you analyze that. This is a phenomenal UVA Law School video of this is a law professor talking to first week law students on how you read a case. If you all start now reading a case this way, whether you're going to be a paralegal or going to law school, these are skills that are going to help you elevate yourself to where when you start working, where you start arguing your positions, where you start expressing yourself, you can do so in a higher level. So watch this video when you have time to pay attention to it and focus on it. This is one of those that will really give you the baseline skills to move to the next level. There is a lecture from me and a PowerPoint that I created for this week. I do want to remind you guys, and I can't believe it's week 4 and some of you all need reminders, that in your work you need to be citing the textbook. To get to your textbook, you click on course materials. It will take you to this textbook. The citation for your textbook, the full citation, can be found here. So when you're writing your paper, here's where you can get the correct citation that goes at the end of your discussion post, at the end of your writing for citations to the textbook. For your in-text citation, you're going to take the author's last name, which is here. So you'll take the author's last name and you will put a comma, and then you're going to need to tell me exactly where you found the information in the textbook. So when you have the author's last name, comma, and then the page number. If you're using APA, you're also going to have the year. So you'll go to the citation, and in here it tells you that it was published in 2016. So you will have author's last name, year that it was published, and then comma, PG, period, and a page number. You can find your page numbers here. We're going to chapter 7 this week, and the exact page you're on will be down here. So when you're toggling through the textbook, those page numbers will change. So you will be able to cite to the book and to the page. That is absolutely vital to avoid plagiarism, and it shows how you are using the course materials. It shows that you are reading the textbook. So this week we're on chapters 7 and 8. If you look over here, it divides it up really well into all of the sections, so you can very quickly and easily go to the different sections to get to the information you want. So if you're writing your paper this week and you're using something from preliminary stages of a criminal case, that could very well come up. Let's use the example again of the Miranda rights. That might be a time where you're going to be citing to Chapter 8. So when you're citing to Chapter 8, this is where you'll go. There's the page numbers, and it'll be very helpful for you when drafting the paper. You've got a judicial procedure midterm this week. I am going to make that live right now so you all can access that. There are 50 questions. You have 60 minutes to complete the exam. Make sure that you have read all of the chapters up until today, all the way up through Chapter 8 before you start the midterm exam. So you're going to want to do all of the readings before you do the midterm exam. You're going to want to watch the video lectures that tie into this. Your midterm exam is predominantly from the readings. There might be a few questions that come from those lectures, but the majority of it is based upon the readings. If you have any questions, please don't hesitate to email me. Have a great week.